and this is SB 585. Good evening, and thank you for your patience.
Good evening, Madam Chair and members of the committee. Thank you for your patience and long day today. So it's my pleasure to be here. Before I get started, I really want to thank the committee staff and my own staff for working very hard on this bill to make it a better bill, and I will be accepting the amendments today.
Great.
Senate Bill 585 aims to improve collection of child support owed to children and their caretakers. Specifically, this bill makes it mandatory for insurers, which is currently a volunteer program which verifies insurance payments made to individuals are first used to pay owed child support. This program is coordinated by the California Department of Insurance and Department of Child Support Services. Currently, the in-state collaboration with over 300 insurance companies nets approximately $17 million annually to help improve the quality of life for children in California. That's about $1.4 million per month going to help families in our state.
Do we know, by the way, how much is owed that we aren't able to collect? You say 17 million
yes,
over the course of a year.
Yes, I think it's about 18 million, or excuse me, 18 billion in arrears. So yes, very good question. 1.4 million going to help the families. Insurance companies of all sizes are working with the state to ensure that kids, and largely their mothers, are receiving the child support that they are owed and they deserve. California is not alone. Every state participates to some degree in the program, which matches insurance payments to past due child support. At the moment, 6 states have been very successful in requiring mandatory participation, including Texas, Massachusetts, and Pennsylvania. In a recent example, Texas intercepted an individual insurance claim in the amount of $117,000, which paid all the back owed child support. Members, before you today is a program that works and an opportunity to strengthen our commitment to children and the parents who care for them. It is critically important that families receive the financial support they are owed to support children, and this is a large part of their income for most eligible families. I have some quick facts for you, but in the interest of time, I'm going to skip those unless someone needs it. Unfortunately, it is well known that most families are not receiving all the back child support that they are owed. In California alone, to Madam Chair's point, $18 billion is outstanding. Across the country, that amount raises to a whopping $116 billion in unowed child support.
Unpaid.
Unpaid. Owed and unpaid. Thank you. Maybe I'm the one who's had the long day, not you guys. You're much more on your game. The Department of Insurance and my office have engaged with stakeholders to work out issues raised in the first policy hearing, and I look forward to any further discussions. In support of children and a program that works, I would respectfully ask for your aye vote. And here to testify with me today, Robert Harrell from Insurance Commissioner Dave Jones's office, and George French, all the way from Rhode Island, from the Child Support Lien Network. And Terry also is here to support. Thank you.
Welcome from New England and the home of the Boston Red Sox, who aren't doing so badly relative to last year. But anyway, yes, go ahead.
Madam Chairman and members, Robert Harrell, Deputy Insurance Commissioner with the Department of Insurance. We want to thank the author and the stakeholders who worked very hard on this bill. Long story short, you've had a long hearing. I'll try to be brief. You have about a quarter of the companies participating voluntarily. There are a few companies that are doing this voluntarily in all 50 states, and in a moment I'll highlight them. You have 6 states that have made this a mandatory program. So any national insurer that has a presence in Texas, in Pennsylvania, in Oklahoma, in Massachusetts, in Rhode Island, or in New Jersey, thank you, they are already complying with this right now. We believe roughly that based on the $17 million we get a year right now on the voluntary program, with roughly a quarter of the insurers participating, we can get into the pockets of overwhelmingly poor women another $40 to $50 million if this bill becomes law. That is without cutting any other program. That is without making any of the tough choices that you've all been making over the last few years in the budget and elsewhere. I'm happy to answer additional questions. I did note highlighting some companies that are doing the right thing. One of them is sitting right next to me today. You'll hear from Mr. McHale in a moment. Liberty Mutual is voluntarily participating in all 50 states. Zurich is voluntarily participating in all 50 states. Travelers is voluntarily participating in all 50 states. And Mercury is participating in all 50 states. The last one is an interesting one because that's a company that is fond of suing the Department of Insurance. But when they do the right thing, we should point that out. So with that, we respectfully ask for an aye vote.
Thank you very much. Next witness.
Madam Chairwoman, members of the committee, Terry McHale from Aaron Reed and Associates representing USAA Insurance. It is true that we already do this in 50 other states voluntarily. We're one of 309 companies that work with the Department of Insurance in California already to get this done. In Massachusetts, they've been doing it since 1999, and the federal government called it an ideal program for reaching out to vulnerable children in the United States. So it can be done. We were concerned that this was going to go around the Administrative Procedures Act. We're pleased to see the 2 amendments that were taken to deal with that, and also the indemnification of those insurers that try to do it in good faith. I would close by saying this. USAA has said clearly that the rules when it comes to support for children should bend demonstrably in the direction and the protection of the child. This can be done. We can work with the department, and we would ask for an aye vote.
Thank you. And even though we've got a 2-person rule, you came from Rhode Island. I need to clarify that the Red Sox are in Boston, but Rhode Island has adopted them generally as their team. So I want to be clear on that. So please, thank you, and go ahead. That's right. That's right.
Thank you, Madam Chair. My name is George French. I'm the project director for the Child Support Lien Network. The Child Support Lien Network is hosted by the state of Rhode Island, has 31 states in the program. And basically, we have developed what I think is a very good system, that it's a win-win-win. Win for the children and families, win for the insurance industry, and a win for the child support agencies across the country. We basically take the delinquent obligors and match them up against insurance claims for personal injury and workers' comp every day. We make sure that the claim is still open. We make sure we get the appropriate contact information within that claim, and then we release it to the state for processing. In the state of California, you folks have been in the program since 2002. You have just over 319,000 obligors in our file, as well as owing $12 billion. So there's another $6 billion out there that we don't have record of or part of our program. This program, I think, is really a credit to the insurance industry. It's a public-private partnership that's been formed for over 15 years, where we have really worked through the logistics to streamline this process. And to the insurance industry's credit, 85% of all the companies that are participating in the network participate in all states. Robert mentioned a few of the big players and so forth, but there's tremendous goodwill here for not only for the insurance industry, but as the Senator mentioned as well, the opportunity to increase child support collections for the children and families in California.
So why would any insurance companies, to your knowledge, oppose this bill?
Well, you know, I think it's just it's a legal issue. I think from the perspective of, you know, the legal teams will review the legislation and review the process, but like I said, the majority of them are all coming in. There's a few big players that could really make a difference. I've knocked on the doors of State Farm. I've knocked on the doors of Allstate. I've knocked on the doors of Nationwide. I've met with all of them. And to their credit, they have stepped up and played within the mandatory states. And I think State Farm, Allstate, all by themselves can change the dynamics of child support collections in this program overnight. And we're hoping that by getting a state like California to adopt a mandate, that they will see that this is the right thing to do on their side too, and come forward and participate in all states.
Thank you very much. Do we want to go ahead and call the opposition? Any other witnesses in support? Let's hear from the opposition. 2 witnesses, please, unless you're from Rhode Island, and then we'll give you an extra minute.
Good afternoon. I'm kind of in a tweener position. I'm Sherry McHugh. I represent the Pacific Association of Domestic Insurance Companies. We are very thankful to the author and her staff for working with us, and we appreciate the amendments that your committee staff outlined in the analysis, and we think the bill is a a definite improvement over what we heard in insurance, and we think we are prepared to be neutral on the bill as currently in print with the additional amendments. What is of concern is we are hearing and understand that the penalty provisions may be strengthened. With the penalty provisions as currently in the bill, we would be prepared to be neutral, but if they are strengthened, that would cause us concerns. Our ultimate goal is to make sure that these families get the money they deserve, and we're a little concerned about taking a voluntary program that is working quite well, and now adding these possibly very strong penalties and giving our regulator the authority to impose these penalties on us, even if we're trying to do the right thing. So that is of concern.
So what are the penalty, or what are the concerns about penalties if you're trying to do the right thing? What is it about the requirements that you think would expose you to potential penalties if you're trying to do the right thing?
The penalties in the bill today, we believe, are fair, that if we fail to get a match, if we fail to do the matches correctly, then we can be fined up to $1,000 per violation, and the commissioner can order us to comply with the matching requirement, which we think is fair. There's been some discussion about adding to that the requirement to also make the family that we failed to match correctly whole. And depending on what that type of claim payment could be, that could be a very large amount of money. And if we've already paid the deadbeat parent, then we would essentially be paying that claim twice. So if that provision is put into the bill, which we've heard it might be, that would, for the smaller insurers that I represent, that could be very, very costly.
Okay. Thank you. Can we hear from, is State Farm here? Is Allstate here? Would you share with us why you're concerned about this when you're doing this in other states? They're not here. Well, okay, then step up and tell us who you represent, since those were two companies who we were told would be game changers if they would come to the table.
Thank you, Madam Chair. Senators, Julianne Broyles here on behalf of the California Association of Joint Powers Authorities. We're a little different. We're not an insurer. In fact, it's specifically stated in the government code, we're not insurers. This bill is attempting to put us underneath the regulatory authority of the Department of Insurance for the first time. We do have had, I thought, a productive discussion with the sponsors of the bill today on a conference call and with the author's staff. However, the piece that we are now, I think we came to understanding what they were trying to accomplish with the bill, but with an additional change to the penalty provision where they're trying to say you're going to make whoever is the obligee of the child support payment whole. That's very different. When you go and settle a workers' compensation claim, even when child support liens are present, the whole amount.
Can I just interrupt for a second?
Yes, ma'am.
I was just advised that you're talking about something that isn't in the bill presently?
That is correct.
We were informed by the sponsor that it is to be added to the bill.
That hasn't been brought to my attention that we're going to add it. I am very comfortable with the current penalty, so that has not been
I think you should talk to the author. Even though
I shall.
sponsors sometimes think they're in charge here, we think we're in charge.
I will stop there then and say, if it proceeds as it is currently written, we would ask for one technical amendment where you have in the second proposed amendment that insurers would not be civilly liable if they did a good faith effort to do the matching. I think you need to specifically state that our self-insured risk pools also would also be covered by that liability protection.
We'll certainly take a look at that.
Thank you, Senator.
Thank you.
Mark Segna with the Association of California Insurance Companies. We continue to have a few concerns with the bill. Some of them have been mentioned before. The penalty, we've worked very closely with the author and her staff. I want to thank them and the committee staff. We're not necessarily opposed to the concept here. We just want to make sure that the bill is workable. One of our first recommendations would be that the bill recognize the voluntary efforts that are already being undertaken, and the bill was amended to do that. We continue to have some concerns with the penalty provisions in that we want the penalty provisions to be consistent with what other financial institutions and other similar situated companies are. It is my understanding that banks have a $50 per incident fee up to $100,000 a year. This seems to be a lot larger than that, so we need to look at that. We We also want to make sure that the timeframes are workable in terms of the data match. Massachusetts was mentioned earlier. Massachusetts data matches takes between 7 to 10 days, so that may be difficult for us to also meet our statutory requirement timelines, particularly in workers' comp and some auto things where we only have 20 days or 30 days, so we're going to have to work out that. And then the other issue is a lot of these claims, particularly on the personal auto side, tend to be very small claims. Many states have adopted a minimum threshold before you have to do the data match, and that may be something we would like to consider. Thank you.
Thank you. May I ask this question? How long does it take to do a data match? You know, in today's world, assuming that our IT is working, how quickly could we get this done?
I don't know, but I would refer to Robert, or I would ask George to answer that question since he's doing it in his state. I can't
George,
imagine
you want
it
to
would
tell us what
take
they're
too
doing in
long.
the great state of Rhode Island? Don't knock New England, fella.
But
Don't
that,
knock
just to
New England.
clarify, Senator, that system is not unique to Rhode Island. It became one of the de facto national systems.
Yeah. There you go. Well, they're doing it in Texas and Massachusetts and, you know, so it's not just Rhode Island. But how long does this take?
The whole process, Madam Chair, takes within 24 to 48 hours. The difference between what the Child Support Lien Network is doing and some of the traditional data matching is we're matching every single day. The obligors are bumped up against the insurance claims, and they come to us every single morning, 5 days a week. The QA process takes maybe 24 to 48 hours, where we then release the match out to the state for the processing of the lien.
Okay, that answers that question. Next witness, please, very briefly.
Okay, Ted Angelo with the Association of California Life and Health Insurance Companies. I would echo the comments that were stated before. Significant to us, and first, we do appreciate the author working with us and accepting the date to implement 6 months forward. That'll help us with the compliance concerns. I mean, only 309 of 1,240 admitted companies are doing this right now. There's a reason. We want to ensure that compliance issues that occurred in Texas, we heard a little bit about how Texas was working well. There were compliance issues in Texas. It's a big state, like California is a big state. We want to make sure that we work out these issues before we go live. And that's a concern to our members. I think with annuity and life insurance payments, it's a newer process that wasn't done in some of the other systems before. They may be now, so that's also something that we needed to consider and that we're talking to the author and staff about. And I think I'll leave my comments there.
Great. George, can you tell us a little about the compliance issues and how you deal with those?
Yeah, the situation that I think the gentleman's referencing.
And I apologize, I don't remember your last name, but you're
French.
George, and I like your accent, so.
I didn't think I had one. So.
Yeah.
The situation in Texas, I think that we've come up against was with property damage claims, which are, you know, handled very fast. And I think the senator has taken that part of the insurance claims out of this mix. As far as life insurance is concerned, again, we're moving towards a data match. There isn't a repository of data matching of clients or claims for life insurance. So we're doing direct data matching with the insurance industry, different companies, as well as a interactive lookup site. In the state of Texas, in the last 2.5 years, they've collected over $20 million in life insurance. So I think it's an important element, a great opportunity, again, for the state to incorporate that into this bill.
Thank you. Any other witnesses in opposition? Very briefly, if you would.
Steve Suchel, American Insurance Association. We'd like to echo a lot of the former comments. We're gratified that the bill was changed with respect to regulation adoption and the immunity. And if there's further discussions on the fines, we'd appreciate that. But overall, our opposition would have been lifted. We're now neutral.
Great. Any other witnesses in opposition?
Amber King with the Alpha Fund. We're a self-insured workers' comp pool. We support the intent of the bill, but also like to make sure that it's workable within the workers' comp system.
Okay.
Madam Chair and members, John Norwood on behalf of the California Insurance Wholesalers. And these are, again, I don't think anybody objects to the intent of this bill. It's all about workability. Same thing for the clients we represent are what's known as non-admitted insurers. These are insurers that are admitted in other states, not in California, in other nations and islands, Lloyd's syndicates, those type of things. And we just want to make sure that they all know how to do this and, you know, have the procedures down, because those are not as easy to approach. And I just want to keep working with the
Talk to George.
sponsor and the
He'll tell you how to
department on
do it.
how we make sure we get that done. Also, small companies that are operated by what they call managing general agents. We just want to kind of get everybody up to speed so that we can comply with the law, and that'd be great. We support the bill as it is. Thank you.
Senator Hertzberg.
You know, in my past life, one of my many iterations as a haberdasher, I was a partner in a child support collection agency, and I got some experience in this business, and it's a great cause. Because of that, I've got a couple of practical questions. I don't know for the appropriate persons. Maybe it's Rhode Island, I don't know.
Throw them out there and we'll let you know.
Throw them out, thank you. You know, because I'm really concerned about the unintended consequences in the context of how this actually works. What happens is this lien, let's assume it's a traffic accident, I mean, a collision, right? The lawyer takes her fee, right? And then there is a balance of money that gets transmitted to the client. Sometimes doctors, there's reinsurance companies have reimbursements, and then you've got to, out of the money that you get, got to pay the doctor. Sometimes the lawyers take it, sometimes they negotiate the liens. These things, I've been through this years ago, and they're sloppy. They're not really cool. And so what you're going to, I'm just worried about unintended consequences. You're going to have all these competing liens, and you create a problem. Is that been something that you have, that you've experienced as because ultimately you want to get the net dollar that goes to these folks, and then from that, make sure that it goes to the proper parent. And then one other question, just to add to, you can add this in thing, is the whole idea of sometimes folks will go out and you see these advertisements on television where people will get liens and prejudgments money. You need cash now, you got an auto accident, we'll advance you the money. I don't know how the legal things are. I'm just trying to figure out how to avoid that. And if you've thought it through, hallelujah.
I think we have, and I can tell you from experience that we haven't had any of those circumstances come up. Exactly what happens is the obligor's money that would traditionally go in his or her pocket is all that gets intercepted. All the medicals and all the legal bills are paid before. We would never have gotten this thing past ground zero if we were taking any legal fees or medical fees from the beginning. So it's worked very, very successfully in 31 states. We thought we'd have a lot of pushback from plaintiff attorneys. Absolutely nothing.
But the check comes in these situations, the check gets written out to, there's a settlement for $10,000. That settlement check gets written to the law firm and sometimes to the doctors and the plaintiff, right? It gets deposited appropriately in the lawyer's trust account. The lawyer then pays all the distributions and nets the dollars, whatever the dollars are, to the client. Is this something where the notice goes to the law firm in these cases where there's deals, and then the lawyer simply treats it like any other lien?
Yes, when we're made aware of any attorney involved in the system, they're also getting a copy of the lien. The insurance company will also communicate with any attorney in the settlement. But there's a lot of these, and particularly in child support, don't have an attorney associated with it. It's really a pretty quick process.
And for this law with respect to the Department of Insurance, you agree with his analysis with respect to how this bill works? Do we consider those unintended consequences?
We did, and we've consulted in great detail with the Department of Child Support Services on just those issues in terms of what I refer to sort of as the order of operations, if you will. Yeah. I mean,
did you look at this issue of these companies out there that take advance monies against your settlements?
I have not personally looked at that issue, Senator.
I don't know, I just saw it on TV, you know?
I will now.
Yeah.
I have not looked at that personally, but we will, if there is anything that needs to be clarified there, we're happy to do so. If I could, through the chair, just to clarify on penalty, just to put a little bit of context here to the penalty conversation. Oklahoma, penalty up to $10,000. Rhode Island, a penalty of between $100,000 and $50,000. So we're actually very, very mild on the penalties. I'll be honest with you, we had floated some language about $1,000 and make mom whole, which is what I'm referring to, because overwhelmingly we're talking about poor women. That is the case in some other states. That is apparently what is making the insurers grumpy. It's beyond me as to exactly why, but these are one-offs. These are not, we're not talking about tens of thousands of claims that are running through simultaneously here. Texas makes the mom whole. Oklahoma, the fine of $10,000, and they make the mom whole. So I just wanted to put a little bit of context on the penalty conversation that has occurred.
Thank you. Any other questions? This is really important, that there are just too many people and children who are going without the support that they're entitled to. It affects levels of poverty in this state. It affects the ability of working primarily moms to be able to care for their children rather than have to go out and work just to put food on the table. These are deadbeats. I know from my experience in the area of family law that the amount of child support that's ordered is very rarely sufficient. When we can't collect it, it's a detriment, a severe detriment to the children of this state. We owe them better. And I would like to see this measure proceed. I appreciate the concerns that were expressed. Here's our expert here all the way from Rhode Island. French Rhode Island? No, that's a good New England accent. It seems to me that if they can do it in Rhode Island and Massachusetts and, my God, in Texas, we can do it here. And there's no excuse for us not doing it here when we're leaving, what was it, $18 billion a year? $18 billion a year that should be going to the children of this state, and the millions that we could put back into the pockets of their parents so that they can support those kids. To me, the policy is so clear. So I will hope and look forward to seeing this measure move forward. I guess we have New Jersey, Pennsylvania, Texas, Massachusetts, Rhode Island, and Oklahoma.
Madam Chair, I move the bill as amended.
Moved by Senator Leno, and this is due pass as amended. Thank you for taking those amendments to Senator Probst. Please call the roll.
May I just say one thing before we
yes,
call the roll?
you can close.
Okay, thank you. Thank you, Madam Chair, for your comments. Thank you, members of the committee. I just want to close by saying that this is incredibly important. And I know that the insurance companies, when I met with them, they do not oppose this philosophically at all, which is really, really important. The reason that I'm comfortable with the $1,000 penalty is because I think, and I'm a new legislator, so maybe I'm wrong, but I think if we find there's a problem, we can always come back and we can always strengthen that penalty. So my hope is we're all going to work together and do some real good for families here in California. So thank you so much, and I respectfully ask for an aye vote.
Thank you. All right, there's a motion, and it's due pass as amended to Senate Appropriations. Please call the roll.
Jackson?
Aye.
Jackson, I. Morlock. Anderson? No. Anderson, no. Hertzberg?
Aye.
Hertzberg, I. Leno?
Aye.
Leno, I. Monning? Aye. Monning, I. Wachowski?
Aye.
Wachowski, I.
5-1, that bill is out. Thank you, Senator Leyva, and thank you.
Thank you.
Thank you, Madam Chair.
Talk to those folks and figure this out. Come on, if they can do it in Oklahoma and Texas, we can do it here.
It's doable. Okay.
All right, our next item is
Number 5.
item 5. Item 5, is that 5, Senator Wachowski?
Yeah, this is 5.
All right, we're now at bills being brought by members of the committee. We'll start with Senator Wachowski and then go to Senator Monning and then Senator Leno, and then I will do mine last. All right.
Senate Bill 117 extends the sunset of the existing law that allows alarm companies to form limited liability companies. I'm accepting the amendments set forth in your committee report that will shorten the period from 5 years to 3 years. I have with me Trent Smith with the California Alarm Associations, who has a breadth of knowledge on this area, and he's here to answer questions, and I urge your aye.
All right, we have a motion by Senator Hertzberg. I'm told that once we make the motion, identify it, we can't have any further discussion. I don't believe there is any opposition, is there? There isn't? Okay, a motion which is due pass as amended to Senate Appropriations. Please call the roll.
Jackson?
Aye.
Jackson, I. Morlock. Anderson? Aye. Anderson, I. Hertzberg? Aye. Hertzberg, I. Leno? Aye. Leno, I. Monning? Aye. Monning, I. Wachowski?
Aye.
Wachowski, aye.
All right, that bill has 6 votes and it is out. The next bill is Senator Wachowski's SB 308, number 15. Good afternoon, good evening.
First off, I'd like to thank the committee for its work and say that I'm taking as author's amendments that are noted in the analysis. The homestead exemption will be reduced from $700,000 to $300,000. I know that you're all aware that I've been practicing in the bankruptcy arena for 28 years or something like that, and I have some firsthand knowledge of some of the elements that are contained here. I have a couple of practicing attorneys here. The suggestion that people are going into bankruptcy and have a lot of money is just nonsense. From 2005, when we had the BAPSIPA, which is the Bankruptcy Abuse Prevention Act, and Consumer Protection, we have had nearly 73% of filers earn $40,000 or less, and nearly 40% of them earn $20,000 or less. These are low-income people, and despite that, many of them are still employed at the time when they're filing, and they just don't have enough money to dig themselves out of the hole. So SB 308 stops trustees in bankruptcy from taking over someone's employment claim and settling it to pay an unsecured creditor. Let's see, where am I? Oh, no, it's good. 308 will allow debtors to have a much better shot at becoming self-sufficient, avoiding consuming more bad debt, and being forced onto public assistance. I have with me from the National Association of Consumer Bankruptcy Attorneys, Mr. Ike Schulman and Norma Hammonds. And I urge an aye vote.
Thank you. Witnesses in support.
Yes, thank you, Madam Chairwoman, and the members of the committee. We are here to support Senator Wachowski's bill, and we're very appreciative that he's taken the time to go into a lot of detailed areas of the bankruptcy law and how it works for Californians to fix a number of problems that we currently have. And to highlight the most imposing problem we have right now is the inadequacy of the California homestead exemption. Right now, a single person gets a $75,000 homestead exemption, a couple $100,000, seniors disabled $175,000. That's woefully inadequate for anyone to attempt to save their home equity and purchase a replacement home. Unfortunately, California has lagged far behind the rest of the country in most states in keeping up with protecting homesteads. Just last month, the Legislative Analyst's Office here produced a report, California's High Housing Costs, which documents how significant the increases have been for cost of housing in California and how they far outstrip the rest of the country. So this effort, which is now a $300,000 across-the-board homestead, will make some progress in enabling people to who have a home to keep their home equity if they're forced into bankruptcy. Connected to the homestead exemption is a fix that the senators proposed in eliminating the 6-month reinvestment requirement that's currently in the California law. And up until 2012, we didn't have a problem with that because bankruptcy trustees in a pending bankruptcy would not sell a home and try to recoup the home equity because they didn't believe they had the authority. There was a Ninth Circuit Court of Appeals case called In re Jacobson, which is mentioned in the letter that I sent to the committee, which basically stated that's not the Ninth Circuit's opinion. And from that case and on, for the last 3 years, anyone filing bankruptcy with home equity in a Chapter 7 is at high risk of having a bankruptcy trustee come knocking on the door 6 months later after the debtor couldn't reinvest in a replacement home and say, I want all the money back.
Right.
And
thank you. Appreciate it. Okay.
And one other point that I want to mention is there's also in this bill a very small, what we call a grub stake exemption of $5,000 for entrepreneurs, self-employed folks who, if they use the Section 704 exemptions, do not have any cash that's also exempt, unlike wage earners. So if you have a landscape contractor and he works for a month and he bills at the end of the month for all the lawns that he's managed and all the hedges he's cut, all that money will go to the bankruptcy trustee today. Okay. So this will modest increase and needed.
Thank you very much. Very briefly, those also in support.
Thank you.
My name is Norma Hammis, and I'm a practicing bankruptcy attorney in San Jose for 37 years, and I'll just add my support to the bill as well.
Thank you very much.
Thank you.
Anyone else here in support of the bill? Anyone in opposition? All right, the opposition, please come on forward.
Afternoon, Madam Chair and Senators. I guess it's still afternoon, not quite
guess.
evening yet, getting close to it, though.
Feels like tomorrow.
Alex Alanis with the California Bankers Association in opposition to the bill. We're glad that the Senator took the amendments, but the bill's still going to benefit higher income earners and not going to help poor working class folks. This is still a bill that would actually allow higher income folks to shield their money from creditors. And it's not necessarily just creditors, banks, and other folks, but it also includes child support payments, alimony, taxes, unpaid wages. Creditors are actually further back in the line, and so other folks that are needed from someone filing bankruptcy will actually be harmed by the bill. The analysis does point out, though, that the thresholds for the homestead were increased not that long ago, just a few years ago, and then there was a consumer price index mechanism that was applied there to allow for increases in inflation. And it's reviewed every 3 years, and then that is increased. It hasn't been in process that long, but we do have a mechanism to make increases that are necessary. I just want to make sure that the issue of home prices and equity in a home aren't conflated, because that's what I keep on hearing. This is equity in a home, not necessarily the cost of a house. So we're not dealing with a $300,000 house. We could be dealing with $1 million house that has a mortgage of $700,000 in it. So it's still going to impact folks who have higher incomes in the state. It establishes an unlimited homestead exemption for smaller agricultural property, which in some parts of the state could be worth a lot of money. So places along the coast which have higher values of property will probably be a little more expensive and allow folks to shield their income from creditors. And then in addition to that, as was mentioned earlier, it allows for shielding of more funds in businesses, in vacation credits, and other employment benefits that the creditor who does owe money to worthy individuals and groups should pay and should not be allowed and be rewarded.
Thank you very much. Next witness, and then we'll let the senator respond. Go ahead.
Madam Chair and members, Monica Miller on behalf of the California Association of Collectors in opposition for the reasons previously stated. Thank you.
Thank you very much. Senator, would you like to respond to those concerns?
Yes, as I indicated, the federal government, signed into law by George W. Bush, had changes in the bankruptcy law that set up a means test. So this idea, there's stopgaps that occur in the bankruptcy law to prevent the gaming of the system. First, there's the means test, and we shouldn't just gloss over this. You first have to submit 6 months of wages to the court to determine what your average income has been, and if you make too much money or you have too many assets, you do not qualify to file a bankruptcy petition. The second, even if you get past the means test and there's a clawback rule that allows the trustee, if somebody's made some frivolous purchases or they've transferred some money, the fraudulent conveyance or avoidance powers of the bankruptcy court can gut that and bring those assets back in so they're administered. That's what these people do for a living. And then the third is if people intentionally delay the filing of the bankruptcy, the trustee can still go back and pull those things. So these are tools that are available to them before you even get to the exemption schedule. As I've indicated, and I'm willing to accept the amendment to the exemption so it's $300 for all people, so we don't determine whether you're married or divorced or unmarried. The average home price in California is $415,000, or it's $455,000. It keeps going up, and the CPI that we've been hearing about does not apply to the homestead exemption. It only applies to the other exemptions that we have. It's not to the homestead. So there are protections that are already built into the federal code. And with that, I'll use it as my close. Close.
But before you do that, would you, my understanding is that you're going to strike the no acreage exemption, which was raised?
The farmers?
You want to take a second?
Yeah. I thought I was reducing the homestead exemption to 300,000.
That is my understanding, yes.
Yeah.
And there was concern about the unlimited
Right.
nature of the homestead exemption for
family farms, that they would be able to, they would be able to, I mean, a lot of family farms are larger than 320 acres.
Hold on 1 second.
That was,
Yeah. I believe it was our understanding that the 300 was at a flat
is the
exemption.
opposition withdrawing their opposition if I take the amendment to take out the 320 homestead exemption? Is that what the understanding?
That seems like a fair question.
No.
Okay.
No, but that is quite a large exemption.
Well, this is, as the analysis points out, Madam Chair and members, that the homestead exemption originated in 1901 so people can stay in their home. In their home. And the reinvestment, as we said, was to keep them in their home. We want to have a house. Farmers, the small farmers out in the valley, we haven't been doing something. In yet another compromise, I will withdraw that language and go with a flat $300,000.
Very good. Much appreciated.
And that would be my close.
All right. I'm sorry that hasn't moved the opposition, but I'd just like to share, I know in California, there are not too many places where $300,000 as an exemption is going to get you a lot of house when you try to rebuy if you lose it. So I appreciate that your willingness to come to that number, and I think this is a very reasonable compromise given the concerns and given the fact that, this is not an inexpensive place to live. You can't buy a mansion for $200,000 like you might be able to buy in other states.
Rhode Island.
I don't know about that, but we'll ask George. At any rate, thank you for your close. Is there a motion by Senator?
No, I want to move on behalf of Mr. Leno.
All right, Senator Hertzberg's moving this, and the motion is to pass as amended to Senator Probst.
Jackson?
Aye.
Jackson, I. Morlock. Anderson?
No.
Anderson, no. Hertzberg? Hertzberg, I. Leno? Leno, I. Monning? Monning, I. Wachowski.